Criminal verdicts thrown out, prosecutors and deputies under fire, justice delayed as Orange County's jailhouse snitch scandal rages on. Now the key players, including DA Tony Rackauckas, Sheriff Sandra Hutchens, and Public Defender Scott Sanders, sound off. Next on Inside OC. Inside OC is brought to you by 5 Point. 5 Point is an independent real estate development company with assets under management across California. 5 Point is a proud sponsor of public television and community programming. Hi, I'm Rick Reiff. Welcome to Inside OC. On this show, you'll hear from the county's top law enforcement officials and a public defender who has accused their departments of breaking the law. At issue is the county's widespread practice of using inmates as snitches to gather confessions from other inmates that can be used against them. It's legal if done properly, but that's the issue. Allegations of wrongdoing by the county have resulted in vacated verdicts, reprimands, a resignation, an investigation by the State Attorney General's office, and widespread calls for a federal investigation. There are strong feelings on both sides of this controversy, and that was on display at a highly charged panel discussion hosted by the Orange County Register. We'll be showing you highlights of that discussion, but first, here's a Register video that explains how this controversy came about.
Do you need police and paramedics?
There's a shooting next door.
Hey, we've had some shootings over here in Still Beach.
Okay, where?
There's a shooting at Salon Miratage.
Police department, do you have an emergency?
A hairstylist came in and said that somebody's shooting with a gun. He's still shooting right now. He's still shooting right now. Salon Miratage. A gunman came in and killed a bunch of people. They're all dying on the floor.
Okay, we have police and paramedics on the way.
We need somebody here, like, right now.
There's a white man in a white truck.
We were just hoping he wasn't going to kill me.
We're on our way.
It was October 12, 2011. In the aftermath of the mass shooting carried out by a vengeful Scott Evan Decry that claimed 8 lives, Orange County District Attorney Tony Rackauckas led the charge for justice.
The circumstances of this case are so terrible and incomprehensible. I will, of course, seek the death penalty against Scott Evan Decry for the intentional, methodical murders of Victoria Buzo, David Cowett, Laura Allady, Randy Fannin, Michelle Fass, Michelle Fournier, Lucia Condas, and Christy Wilson. We'll make sure that each victim will be remembered, and we'll make sure that we seek justice for each individual person.
A day later, outside the view of the newspaper and television cameras, sheriff's deputies quietly moved Decry to a new location within the Orange County jail system. Cell number 3 of Sector 17 in Module L. Cells, just like the one housed in the Santa Ana Jail's processing hub. The cell right next to Decry could easily be wired for the secret system. Observers call that network the Snitch Tank, a place where investigators hope to glean incriminating statements from Decry, a prisoner with no prior criminal record and certainly no experience in a jailhouse. But in the 4 years since that horrible day, the Orange County Register has chronicled how the District Attorney's Office and local police agencies have been exposed for operating an unconstitutional network of jailhouse informants. It's a revelation that led a judge to bar the DA's office from prosecuting Orange County's worst mass murder case. And now, the use of jailhouse snitches is not only delaying justice in the Seal Beach shooting case, it's literally led to other cases being overturned or reopened. It's resulting in the sort of national attention most don't want. Powerful voices from across the country are calling for a federal investigation of Orange County's justice system.
And now I'm joined by the Register's longtime criminal justice and investigative reporter, Tony Saavedra. Tony, thanks for joining me.
Thanks for having me.
This case, this whole controversy, not just the decry slaying, but the whole controversy over the informants really seems to have engendered strong, passionate feelings on all sides.
Yes, it has. And the reason being is that for the prosecutors, they're usually the guys in the white hats. They're not used to being called cheaters. And Scott Sanders has done so. He said that they have violated the rules of using jailhouse informants and snitches. And Sanders is so passionate because he's a born advocate.
Yeah.
He truly and honestly believes what he's doing, and he believes that he's making a difference right now, and he's putting a dent in a widespread practice that has been going on for 3 decades.
Yeah. Okay. Well, let's now turn to this panel, which was moderated by your colleague, Donna Wares, the managing editor. You were a member of that panel.
That's right.
We're going to see all the participants who took place in this, except you, because we have you on set. But let's now look at this panel discussion, and I think people will get a sense of the strong feelings and the very important issues that are involved.
Why would anybody be interested in using an informant in a case like Scott Decry, where the evidence was exceptionally strong that he was the guilty party? There wasn't any question about it, and there wasn't much question about what he had done, kind of how he had done it. But you know, if you remember the Alloway case, you understand that, and that was the biggest mass murder before Decry. And the Alloway case was similar. It was not a whodunit. It was the arrest was made on the campus at Cal State Fullerton, where all these murders happened. Yet he was found not guilty by reason of insanity. And not Edward Alloway, but so Scott Decry had some psychiatric issues in his past. There were certainly some concerns about the possibility of him deciding to, or his counsel deciding to go after an insanity plea. So when our deputies learned that he was talking about the killing, they thought it was worth listening, and so they talked to the informant. He said that he wasn't asking for anything. He was just he was there. He heard this person talking. He was volunteering information. So what they decided to do was to have a recording, have the jail cell, the 2 cells bugged so that their conversation could be recorded, and then any future statements made by Decry would be very clear. There would be no need to depend on the reliability of the informant in order to tell our deputies what those statements were. It would all be tape recorded, and you could listen to it. And they instructed this informant not to ask any questions because Scott Decry had already been charged with the crime. He probably already had counsel, and defendant has a right not to be asked questions when he's in jail and he's been charged with a crime and has counsel. So they instructed him not to ask any questions, but simply to be a listening post. And then, sometime later, some days or weeks later, after there had been a lot of conversation, the Seal Beach police detective then, got the tapes and listened to the tapes. And the statements that he made were just chilling statements of the crime, why he did what he did, how he did it, how much he hated his wife, how much he didn't care about the other people, how methodical he was, and actually pretty darn good evidence that would, as far as the insanity, to rebut any possible insanity defense. And so having received that, then our deputies made discovery to the defense to the extent of telling them, about the informant, about the tapes, give them the tapes, and so forth.
Their plan was to never let us know anything about Fernando Perez as an informant, and that's an important point. We could have easily been here today without that ruling in January of 2013, having no idea who this person was. And what we found as we got the materials, we basically got the materials from all of the 10 cases in which he had provided information. So the statement that Mr. Perez had indicated that he didn't want anything in return was belied by the fact that, and easily understandable by prosecutors, by the fact that he was a third striker who had been convicted. The prosecutor in that case, Eric Peterson, had recommended a 25 to life sentence. And so he had all the incentive in the world to work off his sentence in whichever way he could, and that's what he did. For a year, his only job in custody was to work as an informant. That's what he did day and night. He produced 200 pages of notes. He talked about all his activities in a wide range of cases.
What's wrong with it?
There's nothing wrong with the fact that he did the work, as long as that work was done legally, in the sense of he's not questioning inmates who are charged with crimes. And it's also not wrong if you turn over the evidence that allows people to evaluate the credibility of informants and determine whether that Messiah violation took place. We talk about Messiah, that's the questioning of a defendant who's been charged. And when we looked at it, and we started to look at each of those cases and work through those cases, and the notes of a second informant named Oscar Morial, who wrote 300 pages of notes in his work. These two informants basically worked nonstop in the jail for 2 years. To your question, they can do it. And I know that the argument is, and I understand it, that law enforcement needs this work done. Just play by the rules.
Well, first of all, the notion that we have a network of jail informants and we have special handling deputies that are spending all of their time moving these informants into convenient places is false. With respect to Mr. DeCry, Mr. Rackauckas is correct. You know, informants who are in protective custody and inmates who are capital cases or notoriety, or inmates who need protection in our jails, such as child molesters, they end up in these same type of cells because they're in protective custody. Mr. DeCry, in addition to what Mr. Rackauckas said, was placed at the request of nursing staff, medical staff, so that there would be a line of sight because they were concerned that he might commit suicide. So that was another reason why he was placed where he was placed. There's much has been said that we have special handling deputies, and I have 6,000 inmates in my jails that I'm responsible for. And you've heard about some of the kinds of inmates we have in that jail. So I'm responsible for keeping people apart from one another who might harm one another or harm the deputies. And so I'm responsible for their safety and security. That requires a pretty elaborate classification system. You've heard a lot, you've heard TREAD a lot, and you've heard TREAD referred to as a informant management system. Well, it is not. It is a classification database. It is not an informant management system. Every inmate who is booked into our custody is in that system, every single one, so that we have a history of what their priors are, what were they problems when they were in custody before, were they victimized when they were in custody before, where should they be housed, all the things that our special handling deputies work day in and day out to make sure that jail runs smoothly and we can reduce the numbers of assaults on inmates and reduce the number of assaults on our deputies.
And I heard Mr. Sanders' passionate statement here a few minutes ago, but in all of that, in all of those hearings for all of those months with all of those witnesses, there was no intentional violation of anything. There was no intentional misconduct by any of the people in the district attorney's office. Not found. The judge specifically found that any misconduct that he found in the DeCry case was not intentional and was negligent. And so when we're constantly being accused of crimes here, but there's no criminal conduct taking place, and it's Mr. Sanders is saying, wow, we know what's going on because we've done all this work. We've filed thousands and thousands of pages of documents, but the number of pages it doesn't really matter too much. It's the truthfulness of it. It's the importance and the relevance of what he's filing. So there are a lot of false accusations in that batch of pages. The judge in the Wozniak case called when Mr. Sanders was alleging 30 years of misconduct by the DAs, he referred to it as revisionist history and undisguised speculation.
When Mr. Rackauckas says the district attorney's office has been cleared of intentional wrongdoing in all of these cases, that's an absolute fabrication. Judge Goethals didn't clear them of intentional wrongdoing in the cases separate of what happened in Decry. Didn't address that, except to say Mr. Peterson lied or misled. 2 deputies from the jail lied or misled. People were moved improperly, and that wasn't disclosed. Evidence wasn't disclosed. That's not a clearing of anybody from any understanding that I have of the term clearing.
Well, wait a minute now. Judge Goethals.
Can I have my moment?
No, just a second, because Judge Goethals was very clear. He was very clear that the attorneys in the Decry case did not commit any misconduct.
I said except for the Decry case. Except for the Decry case. He came back then, which a point you left, did new hearings in which, by the way, your deputy stood by and let deputies lie and mislead in court. Not once did they stand up to what was obvious perjury and the hiding of evidence regarding treads. If people don't understand what took place in these hearings, you should. In the hearings, we spent 4 months taking testimony in which deputies pretended as if they had no idea whether there was any information out there that could explain or help them understand whether inmates had been moved and the conditions of that. Only through a lucky break that we got a subpoena response that basically revealed treads. Despite what Ms. Hutchens said, no, I did not know about treads before 2014, nor did Judge Goethals, who said in the first 25 years of his career he never heard of the term treads. So what happened was the deputies, over the course of 3 months, basically misled us. We sat there and were misled for 3 months as they pretended they had no answers and no idea how we could get more information about why individuals were moved. Why was the district attorney's office removed? Because the position of the court was the district attorney's office either did not want to or would not turn over that evidence. In terms of
That is not what the judge said.
I'm talking. I didn't
that
talk
is
through
not
you.
the ruling, though. You're saying this like it's some kind of a fact.
You'll have your chance
that
to
was
respond.
not the court's ruling.
You'll have your chance to respond.
Well, I've sent a letter to the U.S. attorney to ask the U.S. attorney to go ahead and investigate our office if they'd like. I would be happy to have them come investigate and clear the air as to all of these allegations.
Clear the air. Clear the ear of the
yes,
allegations.
Clear the air.
Do you have an Orange County Informant Index in your office?
Well, of course we do.
Have you been turning over evidence for the past 30 years from the Orange County Informant Index where there's been Brady material?
We have been turning over evidence as it's required under the rules of discovery for the past 30 years and more.
Based upon what?
All right, now look, when you have an informant, and I mentioned this a little bit ago. When there's somebody who's in custody and that person is an informant, there's a fine line that has to be looked at and drawn, because if the identity of that informant becomes known, then there are people who would like to kill the informant, and so it puts his life in danger. And so even the penal code gives the prosecution not only a right but a duty to maintain the confidentiality of the identity of informants. And so no, we don't publicize the informant index. It would be very wrongful to do such a thing. Mr. Sanders, on the other hand, in the Wozniak case, published identity of informants, witnesses, their addresses, and that sort of thing, risking their lives. And that's the reason why we have to be careful about giving that kind of information up.
Yeah, this is a trust-based system for those of you that don't understand. On both sides, it works that way. We get the discovery that they want to give to us. I don't have a right to invade their office and start searching for things. So when we have an experience like this, the question is, what's the takeaway? Many of us leave it for good reason, not trusting. Informants are the most dangerous witness in the system. I think all of you know it. I think it's widely understood why. They're motivated. Look at Fernando Perez, Oscar Moriel, who've been in custody now for 10 and 9 years. They're working and working so they can get lowered sentences. They're incredibly motivated people. If you will not comply fully with your disclosure responsibilities in this context, don't expect those people on the other side, once we learn what we've learned, to ever trust that with other witnesses and other evidence, you'll turn it over. So the takeaway is, boy, if you're not being clean as can be with informants, I'm not going to believe you're being right in the other context where it's so necessary. So the takeaway here, we've got to be more vigilant. Defense counsel have to be more vigilant. The community has to look at this. And the last thing I'd say to the community, this is up to you. The truth is, sorry, this is gonna flash it up a bit here, but they want this to go away. They don't want to redress. They don't want any redress of the past. If you look at what they did in Rodriguez and what they said in this case most recently, they're actually arguing that the TRED records, if TRED records were held back, we're not part of the prosecution team, so that evidence shouldn't even be considered as you move forward. So the bottom line is they don't want to go back and fix any wrongs. They want to move forward. Let's forget all of this. This is a community responsibility. Community, are you going to say, yes, it's okay, we'll move forward, we'll have new policies, we'll have new directives? Or are you going to insist that if one single person didn't get their evidence when they were entitled to it, that it's going to have to happen? It's only going to happen here if people speak up. So this is your community. Decide how you want your justice system to look now and how it will be looked back upon 10 years from now, 20 years from now.
It's not a question of any of us wanting this to go away. It's a question of what the truth is. It always comes down to what is the truth at the end of all of this. And that's what the justice system is about, is getting to the truth. And the truth of the matter is nobody wants to violate anybody's rights. Nobody gains anything by violating anybody's rights. And everybody up here has been as candid and as open about this as they can be. Is it a perfect system? Absolutely not. Do we learn from our mistakes and move forward? I think that is the question that we have to answer tonight. And I think in this county, we learn from our mistakes and we move forward. But I would say to you very, very clearly, the Orange County justice system is not broken, far from it.
There's honesty in the system. I mean, this is not a corrupt system. This is not a situation where people are hiding the ball and the defense never gets it.
I have an interest as a prosecutor, just like my next door neighbor, just like my friends that are defense attorneys, to make sure that it's a fair system. I think it will be a shame for anybody to think that 280 or so prosecutors don't wake up every morning with the intention of carrying their duties in a fair and just way, to hold people accountable in a fair and a just way.
Well, I'm going to take the journalist position, which is that transparency is often the solution to what we're hearing today. We have polar opposite views of what happened and why. I don't think it's going to be resolved in-house. You mentioned that there may be a federal investigation. I think some outside review, whether it's the grand jury or academics recruited from UCI and Loyola, whatever it is, it needs to happen to resolve the conflict. Why do we have, 6 cases that have been identified that have been impacted by failure to disclose information about informants? How did that happen? How can it be avoided in the future? Whatever findings this outside the House investigation reveals should be transparent and publicly available so that we can all see how these questions can be resolved. I don't think it's going to happen in-house. I think there needs to be more transparency and throw open the doors and get to the root of it.
So, Tony, the only takeaway we didn't see there was yours, because we have you right here. So what is your takeaway from this whole discussion?
That when you use snitches and when you use jailhouse informants, you're using people that have some kind of incentive to lie. And you're using people who want the goodies, who want the the Del Taco runs made for them, who want the cartons of Marlboros given to them, who want, in some cases, the money that's paid to them to be snitches, who want the leniency in their own cases. They want to get off early, and they want their sentences to be lenient. And so you have to handle them with care. And I think both the DA's office and the Sheriff's Department will both agree that up until recently, they had gotten a little sloppy in how they were handling these very, very, very important witnesses.
Okay, well, this is a story I know you'll be continuing to report on, and we're going to be reading you and following it. Thanks, Tony, for coming on. So do you want to know more? The Orange County Register has much more about this, a whole book about it, Inside the Snitch Tank, written by Pulitzer Prize-winning author Edward Humes, who you saw, as well as articles, records, graphics, the video. Just go to ocregister.com, click on the Snitch Tank tab. Well, that's it for now. Thanks to my guest, Tony Saavedra, and the other panelists. You can watch this show and past shows by going to pbssocal.org or rickreiff.com. You can also catch our shows and our post-show open mic chatter on YouTube. And follow us on Facebook, Twitter, and Instagram. Thanks for watching. We'll see you again on Inside OC. Inside OC is brought to you by 5 Point. 5 Point is an independent real estate development company with assets under management across California. 5 Point is a proud sponsor of public television and community programming.